Okay. Hello, everyone. Welcome to today's CLE presentation by Noel Hicks on the topic of tackling mental health issues in community associations. My name is Elena Taylor, and I am the Dallas Area Paralegal Association's medical/PI and real estate section chair. I'm joined today by Laura Kehoe, our executive director, along with Ms. Noel Hicks. We appreciate you taking the time to attend during your lunch hour. Here are some announcements and some housekeeping information. Please be sure to visit our website at dallasparalegals.org and check the event calendar to see what presentations are upcoming so that you can register for those. Also, please be sure to attend our holiday dinner on December 21st. You must register online, and the deadline to register is Sunday, December 10th. You can also prepay for raffle tickets via credit card on or before December 19th. Please note that cash and checks will only be accepted at the door for raffle tickets only. Also, for best practices, can you please input your full name on the screen so that we can confirm who attended this meeting? This will be our sign-in sheet for Zoom, and it's also our checks and balances to help verify attendance. For this presentation, Ms. Hicks has asked that you hold your questions until the end. You can also post your questions or comments in the chat room, and we will monitor those. Towards the end of the CLE, a passcode will be issued, and if you would like to receive a certificate for this presentation, we request that you send a request via email to myself, Elena Taylor, at etaylor@foxrothschild.com, along with the passcode, and a CLE form will be sent to you. This presentation does qualify for TBLS credit. So please notate on your request if you would like to receive credit. I would like to present our speaker, Ms. Noel Hicks. Ms. Noel G. Hicks is an associate in the Property Owners Association Law Section of RMWBH. Ms. Hicks assists single families, residential, townhome, condominium, and some commercial associations with various aspects of property owner association law, including the collection of delinquent assessments and complex deed restriction enforcement issues, developing and interpreting governing documents, and drafting and reviewing contracts. In addition, she works with her association clients on various issues, such as ensuring compliance with state and federal laws, attending administrative hearings, 209 hearings, and board meetings on behalf of her clients. She is a passionate litigator who believes that clients should understand the scope of and have trust in their attorney's representation. She personally strives to make sure that clients have confidence in her level of expertise in the field, and finds it is essential to not only provide fundamental customer service, but also develop a relationship with each client that will hopefully last for years to come. In addition to her work with clients as their attorney, she also works with clients to ensure they are educated in the rules and statutes governing property owners associations. She is an active participant in RMWBH's growing POA, Property Owner Associations Education Program. Noel educates attorneys, community managers, and board members through various webinars, board training seminars, and more. She also speaks statewide through the State Board of Texas and local community associations institute chapters, the CAI, and at the national CAI conferences. She is also helping to expand our education program by developing seminars on diversity and inclusion training. Her efforts in the industry have been featured by CAI, including forming the basis of CAI's Diverse and Inclusive Communities Guide. Her manuscript on overcoming racism in community associations, attorneys as agents of change, was awarded the best manuscript of the 2021 CAI National Law Seminar. She was also awarded Best Manuscript in 2022 for her publication entitled Tackling Mental Health Issues in Community Associations, our topic today. The content of this manuscript was converted into a digital book entitled Minding Mental Illness, A Guide to Handling Conflicts with Residents, published by the CAI. She is also a member of the Texas Bar College. She received her bachelor's degree from Trinity University in 2005 and her Juris Doctorate from the Thurgood Marshall School of Law at the Texas Southern University in 2008. Please join me today in welcoming Ms. Noel Hicks.
Thank you so much, Elena.
You're welcome.
Does anybody else get embarrassed when people read their bios like that? Like I don't know, it just made me blush a little bit. Anyway, thank you guys so much for joining me today Today, we're going to talk a little bit about how to tackle mental health issues in community associations. As Elena mentioned, I am a property owners association attorney. And so many of the topics that I talk about deal with issues that arise in community associations. But I really think this topic is something that kind of transcends community associations issues, because some of the tips and the best practices that I'll give you today are things that you can use in every aspect of life, I think. And so because I'm an attorney, I'm going to give you a little disclaimer about today's information. And obviously, you know, this disclaimer is something that I always give when I'm doing a presentation, basically that the information that I'm giving you is the law as it exists as of today. And this is not necessarily for legal advice, this is just kind of an educational purpose. But if you do have questions or need legal advice based off of the information that I present to you today, then I recommend that you consult your attorney. So I do kind of want to start off by explaining the reason why I came up with this topic. So I had a co-author and Leah Burton. Last year we were working, and actually, sorry, not last year, but several years ago, because this paper we wrote in 2022, but a couple of years ago, we were kind of in the middle of doing the Overcoming Racism in Community Associations paper that Elena mentioned just a few minutes ago. And one of our clients contacted us kind of in a tizzy, dealing with an issue that they thought to be related to racism, and they didn't really know how to handle it. According to this client, there was an owner in the community who had hung a noose in the tree in his front yard, and it had been hanging there for over 3 months. And of course, our initial response was, what do you mean it's been hanging there for over 3 months? What do you mean there's a noose in it? You know, so many questions, right? How could the association have allowed this to continue for such a long time? Has someone demanded the noose's removal? You know, of course, thousands of questions. And of course, the answer to these questions was yes, the association had really reached its wit's end on trying to handle this situation, but that noose was still there and the community was outraged by it, right? So what was actually going on behind the scenes was this owner was a disabled veteran, and they had suffered from PTSD. And every time the association tried to go and talk to them or tried to go into the property to remove the noose, the owner ran out of their house with a shotgun and chased the person off of his property. So of course, you know, we had to give the client legal guidance on the association's liability for creating hostile environment harassment under the FHA. But also, it was clear that there were some other serious mental health issues going on at play here. And so that was how we kind of delved into this topic about mental health, because we could see that it was becoming an increasingly more difficult issue, more difficult problem for our clients to handle in their communities. So as a result, we wrote this paper. And today we're going to focus on some of the major topics of the paper. I'm going to talk a little bit about mental health in the US, and I'll give you a couple of statistics. And I'll talk about COVID-19's effect on mental health, because this actually was what really spurred on this topic. You know, COVID-19 effects on mental health. There have been quite a few of them, and so I want to talk about that a little bit. And then obviously, because this is a legal topic, we'll talk about some federal regulations and case law. I will touch on what a community association's purpose and obligations are in general and as it relates to this topic, and then we'll do some best practices and final takeaways. So the first question that we want to kind of talk about is, what is mental health? Well, according to the CDC, mental health includes our emotional, physical, psychological, and social well-being. It affects how we think, how we feel, and how we act. And it also determines how we deal with stress, how we relate to others, and then how we make healthy or unhealthy choices, depending on who you're talking to. So although the terms can be used interchangeably, poor mental health and mental illness, they're not the same thing. So a person can experience poor mental health and not be diagnosed with an actual mental illness. And likewise, a person can be diagnosed with a mental illness and can experience periods of lucidity or physical, mental, and social well-being. Mental illnesses are one of the most common health conditions in the United States, and they don't discriminate, right? You can any sort of age, any gender, or any culture, that person can have a mental illness as well. Interestingly, 1 in 5 people live with a mental health condition of some sort. 1 in 25 people live with a serious mental health illness, such as schizophrenia, bipolar disorder, or major depression. There are over 50% of people in the US who will be diagnosed with a mental illness or a mental disorder at some point in our lives. Those statistics are kind of alarming. And so that's another reason why it's important to talk about these things and have these conversations, because we need to know what people are dealing with and how to help them. And I know you've all probably heard, we never know what other people are dealing with. So if we are equipped with this kind of information, then it kind of helps us to understand how we should treat others as well. Now, what causes mental illness? This information comes from the CDC as well. There's no single cause. And there are a number of factors that can contribute to a person's individual risk for contracting a mental illness. And so, there could be some sort of early life experience, like a trauma or a history of abuse. Other experiences related to medical conditions, maybe a chronic medical condition, such as cancer or diabetes. Biological factors, right? Chemical imbalances in the brain might contribute to a mental health illness. The use of drugs and alcohol could contribute, and then also having feelings of loneliness or isolation. And that's obviously something that really came into play during the COVID-19 pandemic. So I'm not going to ask you to actually raise your hands, but how many of us know of someone in our lives who is currently experiencing or has had past experience with one of the issues that I just mentioned? Or maybe it's us, we're personally dealing with one of those issues that I mentioned. And I imagine that all hands are getting raised because we all know someone who is dealing with some sort of mental health illness. The reality is that mental illness will either affect us personally or will affect someone in our lives at some point. When you consider that 74.1 million Americans live in HOAs or condo associations or something like that, then it follows that a great percentage of people who are dealing with mental health illnesses or some sort of mental illness lives in a neighborhood that is governed by a POA, and maybe it's their neighbor or something like that that's suffering from this mental health issue. So those percentages that I mentioned, they include board members, they include managers who kind of manage and govern the community, and they may also include attorneys and paralegals as well. So we have to just kind of keep that in mind, because since we're the ones that are providing legal assistance to the community associations, we got to kind of just remember that. And the bottom line is, this is an issue for all of us. It's a big deal, and it's here to stay. It's not something that we can just kind of sweep under the rug and not deal with. I don't know how many of you saw this like meme or GIF, whatever you call it, but when you realize 2022 is pronounced 2022, it's just interesting that, the year 2020 was very, very difficult, and it seemed to last forever and ever. Even now in 2023, when we have pretty much gotten back into the swing of things, we're still seeing those negative effects of the COVID-19 pandemic on all of us, and especially, the area of mental health. So again, to say that 2020 and 2021 were challenging is the biggest understatement of life, especially when you think about it from a mental health standpoint. All of our lives were thrown into a disarray in 2020 when the pandemic forced, schools and workplaces and stores, restaurants, so on and so forth, to just kind of shut down immediately with no question or no indication as to when they might open back up. A lot of people were laid off from their jobs. Many people became remote workers, and many people became full-time employees plus full-time homeschool teachers to our children. And then also, if you just think about the frontline workers who were exposed to COVID on a daily basis, they were exposed to the trauma of people dying and people just being sick. All of that was going on while they were also struggling with the stress and anxiety of trying to keep their jobs while keeping the virus out of their homes and away from their families and their loved ones. So not surprisingly, according to a study from Boston University, a lot of people became anxious and depressed. In fact, the depressive symptoms in adults jumped from 8.5% pre-pandemic to 27.8% in 2020, and then to 32.8% in 2021. I can only imagine what it is right now. According to the study, the elevated rate of depression now affects 1 in every 3 adults. And there was a quote that I thought that was interesting, which read, "The COVID-19 pandemic has been associated with a substantial increase in mental illness. US adults reported an estimated 3-fold increase in the prevalence of elevated depressive symptoms at the start of the COVID-19 pandemic relative to before it. And then since the pandemic, a number of studies have reported worsening mental health across a range of populations in the US and globally, including among healthcare workers, children, and the general public. Depression is costly and increased risk for physical and mental illness, as well as mortality." So this actually just kind of gives us a really good picture of how the pandemic really affected all of us mentally. It's touched every homeowner, board member, and manager, and even the vendors that service communities in some way. And actually, one of the things that we've noticed the most in community associations is that neighborhood civility is on the decline. And when I say that, I mean a lot of times there is, infighting between neighbors. When you go to board, when we often attend board meetings or HOA board meetings, and there are, people screaming and yelling at each other. A lot of the times the owners are, coming at the board for something that they perceive as something that was done wrong. And so civility in general is on the decline, but if you can imagine in a neighborhood, it's really, really falling, by the day almost. And residents are becoming more and more demanding on management and their boards. And so, the lack of being able to socialize and the requirements to isolate, all of those, especially at key development stages for children, that has turned into a lot of stress for parents as well. So there are so many things contributing to, everyone's behavior. And that's why it's really important to kind of talk about this. But so I want to kind of take it over to the legal side of things. And of course, as I mentioned, these are the effects that the COVID-19 pandemic had on mental health, but we do need to speak about, the legal ramifications of everything. And so really what we have to initially discuss is the Fair Housing Act. Now, when you consider mental health issues, you probably don't consider the fact that there could be some sort of claim for discrimination against the community association. Now, I'll talk about this a little bit later, but a community association or a HOA is considered a housing provider under the FHA. And so this is important for us to kind of understand. And there are a lot of questions that come up, right? Like, how does discrimination against a person suffering from a mental illness come into play in a community association context? And not just in a community association context, but in general, like how does that come into play? And then what role does the HOA actually play in, a discrimination claim? What responsibility does the HOA have to its members? But to thoroughly answer these questions, we need to talk about the FHA a little bit and how these laws impact mental health and impairment. So under the FHA, certain individuals cannot be discriminated against in housing. And what I mean by discrimination in housing, there are 4 different aspects of it. First is a housing provider cannot make unavailable or deny a dwelling to any person because of a protected class. They cannot discriminate against individuals in the provision of services or facilities related to their dwelling. So that means like any common areas or recreational amenities that are located in the community. A housing provider cannot make statements that indicate a preference or limitation or discrimination in the sale or rental of a dwelling because of the person's protected class. And they cannot coerce, intimidate, threaten, or interfere with an individual for exercising or enjoying a right or protection granted by the Act. I mentioned protected class a couple of times, so you might know the protected classes, and I'll just mention a couple of them. Race, age, obviously we'll talk about mental health, but that's going to go into disability. So those are some of the protected classes that we need to look out for. And those are the things that are protected by the FHA. So essentially it's unlawful for any housing provider to exclude or otherwise discriminate against a person because they are someone who is associated with a person who has a disability. Now, keep in mind that there are different definitions of disability, but today we're going to focus on the definition under the FHA. And that essentially is a person who has a physical or mental impairment that substantially limits one or more major life activities. As I mentioned before, community associations fall under the umbrella of the FHA because they are considered housing providers. So they are also obligated to comply with its regulations. Now, when we talk about the term disability, we don't always consider that it encompasses more than what is open and obvious to other people. So what is a disability? I just mentioned to you what the definition is, but there are also 3 key elements to this definition. Oh, excuse me. So I mentioned there is the first element is physical impairment. And a physical impairment under the FHA, and it's actually also defined by HUD, is a broad definition and includes mental impairment, such as a psychological disorder, an organic brain syndrome, emotional or mental illness, right? HUD also provides some sort of examples for physical impairments so that people will actually understand exactly what those are and doesn't leave you guessing about what they are. It also will include drug addictions, which I'll talk a little bit later, drug addictions and alcohol, which is pretty interesting as well. The next element is that this impairment has to substantially limit. So substantially limits means that it is a limitation to a significant or a large degree. And then finally is a major life activity. That major life activity are things that are of central importance to daily life. So that is seeing, hearing, walking, breathing, performing manual tasks, or caring for yourself or others. So those are just some examples of what major life activity would be. So essentially under the FHA, again, it's unlawful to exclude a person because they have a disability. And astonishingly, an HOA probably get the most FHA claims based off of disability discrimination. And I'll explain about that in just a second. But that's just an interesting stat to know because there are so many different types of protected classes that are protected under the FHA. And for disability to be the one that leads to more claims against associations than any other protected classes is really interesting. So think about an example here. Perhaps the association has inadvertently adopted a policy that facially discriminates against a person with a disability, or perhaps they traditionally enforce a certain policy which would have the effect of adversely discriminating a disabled person or impacting a disabled person. So disability discrimination can certainly take several forms. And more often than not, the basis of this discrimination or the claims that we review is that the association has failed to improve or approve a reasonable accommodation to its rules, policies, and practices or services when such accommodations were necessary to afford a person with disability the equal opportunity to be able to enjoy a dwelling or public and common use areas. The other aspect is a reasonable modification, and I'll explain the difference between those on the next slide. But another area where HOAs get into trouble a lot is reasonable modifications, and that is allowing or approving a reasonable accommodation to an existing premise to allow a person with a disability to use common elements. And so that would be, for example, installing a ramp or something like that to a clubhouse or a community clubhouse to allow a person with a disability to be able to utilize it. So what are the differences? Excuse me. So a reasonable accommodation is a request for a change to an association's, to a dwelling or an association's common areas or public spaces. Now, in the case of community associations, the most common request for a waiver that we see is for a waiver on an existing rule or policy, because that rule or policy may have a different effect on persons with disabilities than it does on the rest of the population. And that difference would result in a disadvantage to a person with disabilities, even if the disadvantages were unintended and unforeseen when the rule was adopted, because that can happen as well. Now, when it comes to a reasonable modification, the difference there is it relates to a structural change. So as I mentioned, perhaps installing a ramp or something like that to allow a person in a wheelchair to be able to access the community clubhouse. But it's a structural change that's made to an existing premise or a place that can be occupied by a person with a disability. in order to afford them with full enjoyment of the premises. So in the context of associations, again, the most times you see a reasonable modification request is when it comes to common areas, as I mentioned, because structural changes to a dwelling, those often fall under reasonable accommodation definition. And when I'm talking about a dwelling, I mean to a person's own home. And so there's a whole nother process to go through to kind of get that approved by the association. But while an association might be required to allow a reasonable modification to a common area in certain cases, an owner that requests that reasonable modification might be responsible for the costs. So there's a lot of things that you have to actually consider when, that sort of request is being made to the community. Now, a person will generally be entitled to a request for reasonable accommodation or modification if that person meets the definition that I just gave you for under the FHA of a person with a disability. And there has to be some sort of nexus between the disability and the need for the requested accommodation or modification. Now, the nexus just means that there's a connection. So a person that's in a wheelchair, it would be reasonable for them to request a ramp access to a country club or the community's club or something like that. It may not be reasonable for them to request, I don't know, a assistance animal or something like that, which I'll talk about in just a second. But there has to be some sort of connection between the person's disability and the request that they're making. Now, there are situations where a community can deny a request for a reasonable accommodation, but they need to proceed with caution if they're going to do that, because generally, these things really need to be looked at with very close consideration, because denying a request for reasonable accommodation can really put the association in hot water. And what they have to do is they need to make sure that they are balancing the need to be prompt. And when I say prompt, I mean in their review of a person's request with whatever the need is that's being requested by that owner, right? So if it would potentially, after evaluating a request for a reasonable accommodation, if that request would potentially impose an undue financial burden or some sort of administrative burden on the association, then it could potentially deny that request. Or if it would fundamentally alter the nature of the association's operations, then they could potentially deny that request. But generally, when I'm making recommendations to an association that has received such a request, I want to make sure that they're doing what they, the best that they possibly can in order to accommodate this request, if they can, if it's feasible for them to do it. So we're going to talk a little bit about assistance animals, and I'm sure that you guys have had some experience with assistance animals, maybe in your own individual capacity, or you have seen them, or you have heard people in your neighborhood trying to, keep them, that kind of thing. In accordance with the FHA, individuals with a disability may request to keep an assistance animal as a reasonable accommodation to a community's pet policy. So let's just say, for example, we can kind of put this into perspective. A lot of times in a condominium association, for example, condos have pet policies that don't allow certain animals over a certain size, because it's just not feasible for that animal to live comfortably, a huge Great Dane or something like that, to live comfortably in a community association or in a condo association. Well, the FHA essentially says that policy may be valid or may not be enforceable against a person who's trying to keep a Great Dane if that Great Dane is an assistance animal. And so more and more we're seeing headlines like the one that I have here, where emotional support peacock denied flight by United Airlines, or we're hearing people where homeowners are trying to claim a whole entire coop of chickens as emotional support animals. But if the FHA allows it, does that necessarily mean that an association also has to allow it? Do those same rules apply? Well, understandably, a lot of our clients, would prefer not to have peacocks or chickens running around their communities. But unfortunately, the legal opinion may not be as simple as you think. And a lot of times we have to look at what we call the reasonableness standard. And unlike airlines, communities cannot necessarily outright ban support animals. Now, there is a difference between a service animal and a support animal. A service animal is an animal that is individually trained to support a disabled individual. They can only be dogs. So, for example, a psychiatric assistance dog can be used to help an individual, remind them to take their medication. But if we're talking about support animals, these are animals that typically provide emotional or therapeutic support to a disabled individual. And unlike service animals, they do not require training. They don't have to be necessarily classified as a service animal, but they, do the job of relieving loneliness or depression and anxiety or other symptoms that might affect a person's disability. So in terms of requests for a reasonable accommodation, the reasonableness standard can be interpreted differently. So as a result of that, HUD actually published the Assistance Animal Notice in January 2020 to provide guidance to housing providers who are presented with a request for an assistance animal as a reasonable accommodation. And the notice does provide some direction to community associations themselves on how to respond to an individual's request for reasonable accommodation, i.e. them requesting an assistance animal. But let's kind of put this into context, right? So an individual with a disability may be entitled to keep a monkey as an assistance animal, but the individual requesting the accommodation has the substantial burden of demonstrating the need or the disability-related need for the monkey or the nexus, as I was mentioning before. So HUD does not necessarily provide an example of the burden being met in the case of an ESA, but we definitely, have had cases like this where a monkey, for example, is able to open medication bottles for someone. So that means that that monkey can serve as a support animal. So the short answer to the question as to whether or not community associations must allow support animals or emotional support animals, there isn't much that the association can do about this. Ultimately, the association has to be required to grant a waiver from its no monkeys rule. And if the association refuses to do so, it could be accused of discrimination and have a claim filed against it under the FHA. Now, of course, I don't want to get into too much detail about this here, but there are subjective elements of determining what is reasonable and necessary to allow a disabled owner the full enjoyment and use of their home. But again, HUD does provide us with a little bit of assistance here, and we just have to make sure that we are weighing the pros and cons, looking at the association's potential liability in this kind of situation. So here are some examples of assistance animals that we have had requests for, even snakes, and that was very interesting. Now, I'm not going to get into too much case law here because I don't want to bore you guys to death, but I do want to just kind of go a little bit over some of the cases that have come out. These are not necessarily Texas cases, but they are just cases in general that have dealt with reasonable accommodation requests for assistance animals. So that first case there, basically there was a homeowner who suffered from PTSD, and the association that they lived in had restrictions or policies against pets. And so basically he filed a lawsuit against his association and he filed a claim under the FHA. And the jury ended up rewarding him damages and allowed the emotional support dog eventually. And the damages were awarded because the community originally made him remove the emotional support dog. But the holding in this case was interesting because it found that this homeowner, which I'm not going to try and pronounce his name because I don't want to butcher it, but the court found that he was disabled under the FHA and that he did request a reasonable accommodation, and that this reasonable accommodation was necessary to afford him the opportunity to use and enjoy his dwelling. And so this is just kind of an idea of how courts would go about evaluating this issue. And essentially, the facts in this case show that the association took a really long time, more than 6 months, to respond to his request. And that could have been because they didn't know what to do with it. Who knows? But they mentioned that they were still deliberating and needed to add additional information. But the court held that this was untimely, that they should have determined it way sooner. And as a result, he was allowed to keep the animal in the house. There are also cases that deal with the breed of the emotional support animal. So that second case deals with pit bulls. And the association held that essentially pit bulls weren't allowed because there was an ordinance in place that disallowed pit bulls. It was a county ordinance that disallowed pit bulls. And so in this case, though, the court found that changing the policy that the association had in place for an emotional support animal was a reasonable accommodation under the FHA. And so in this case, just because it was a pit bull didn't mean that the community did not need to allow this animal. And just also keeping in mind that because they allowed the animal, it was a pit bull, but they did, caution the owner that the animal could be a direct threat to others because of the breed. So those are just two of the cases, and I'll skip over that Eastwood case, but the last one is a case dealing with a young lady named Erica out of New York, and she lived in a co-op building, which is similar to a condominium in New York. But Erica suffered a stroke at the age of 12, and as a result, she was legally disabled and suffered from major depressive disorder and generalized anxiety disorder. And Erica attempted to harbor 8 dogs, 2 cats in her home, and there was some other animal that she attempted to keep. Now, it was interesting because this is just far too animals for anyone to keep. And if you think about in a condo, there's not enough space for all these animals to live anyway. And the association eventually claimed that the 8 dogs and 2 cats did not necessarily qualify as a legitimate, reasonable accommodation under any sort of laws, not state, federal, or city laws. So they went to Erica's psychiatrist and tried to get some sort of reasonable explanation as to why this might be necessary. They were trying to, create that nexus that I talked about. But in this case, the court basically said that it was not reasonable for her to have that many animals. And so they made her limited to 4 dogs and 2 cats, or 4 dogs and 1 cat. So, of course, we've all no doubt experienced at this point people getting into legal trouble when they decide that they don't want to do what the law tells them to do. And that's part of the reason why we have to have this conversation. A lot of times an association will think that a resident is faking their disability because they just simply because they want to have some sort of animal and the association doesn't allow it. And so the association will seek to deny the request for reasonable modification or accommodation based on that alone. Well, we can't let them do that. We have to evaluate all of the issues, very closely and make sure that we're making the right decisions for our clients to keep them out of court. All right, so the second thing that is a typical reasonable accommodation request that we see is for group homes, and this is related to mental disability. So the FHA prohibits a municipality or any other local government from making land use decisions, and group homes fall under that limitation. So as we determined before, the FHA applies to community associations. And so the bottom line in this situation is an association cannot outright enforce a ban on a group home. Now, the community association can instead ensure that the adoption and enforcement of their restrictions occur in a legally compliant manner, in a manner that does not raise discrimination red flags. And the 2 major concerns that we see with this most often are community associations that have single family use restrictions, and also those who have restrictions against commercial or business use. All right, so as previously mentioned, the association is not completely without recourse. If there is a request for the addition of a group home that might impose some sort of undue financial burden or some sort of administrative burden on the association, then it does not necessarily have to allow the group home. Even if the existence of a group home would fundamentally alter the nature of the association's operations, then it could deny the request. Now, the association does have a strong argument that a group home can, very much so change the residential or the single family nature of the neighborhood, and that allowance of a group home would indeed fundamentally alter the nature or the operations of the community. But we also have to just kind of keep in mind that, this could be considered a violation of the FHA. And we want to make sure that, we're evaluating these requests very closely. Also, we have to look at the fact that allowing such things like group homes could create additional liability and additional duties on the community association. So that's something that we just need to pay attention to. And then also, this doesn't necessarily extend to the impairment of resulting from current illegal drug use or controlled substance use. And I'll talk about that. I mentioned that earlier, that alcoholism and drug addiction can qualify as a physical or mental impairment, but it does not talk about, the FHA doesn't cover current illegal use of a controlled substance. Now, here are some cases that have to deal with group homes as well. And again, these are just important because you can see how these were handled by a court and the context in which they were brought up. So with that first one, a nonprofit organization was attempting to establish a group home for mentally impaired adults in this residential subdivision. And there was a property owner that lived in the subdivision that filed suit and claimed that the operation of a group home violated the provisions of the restrictions. And there was a very specific provision of the restrictions that basically was a single family residential use restriction. And the court actually disagreed with him on this one and held that the location and operation of the group residence, and as long as it maintained the conditions proposed by the person who was attempting to bill it, they would not significantly alter the character of the community. And they would also not add any financial or administrative burden. So the court went ahead and allowed this group home. In the second case, that Deep East Texas case, this one had to deal with the architectural structure of the community. So this one, there was going to be I do not like to use the word mental retardation, but a mental health facility that would be regulated by 2 staff members that would have 24-hour subdivision, and there would be 6 females with mental impairment that lived there. And so Deep East Texas argued that the trial court erred in basically disallowing or preventing the group home from being built there. And basically they said that the court looked at the case above that I talked about just before, the Rhodes case, and they concluded that no restrictive covenant or deed restriction can deny or limit the ability of such disabled persons who meet and qualify under the statute. The statute that they're talking about is the FHA. And so they can live in whatever state that they choose, and including living in community associations. And then there was a public policy argument that basically said that, they needed to go ahead and allow this because otherwise it would be a discrimination act under the FHA. So these cases are important to look at because we can just see how courts review these issues and how they would rule. So in our goals, I mentioned that we would talk about the association purposes and obligation. These are the 4 main tenets of a community association. One of the biggest ones is to preserve and protect property values. That's part of the reason why most people buy into community associations. And if you think about all of these different tenets, as I called them, you can see how mental health issues really could affect every single category. So for example, a mentally ill resident's actions could result in damage to the common area. And so that would prevent the association from maintaining the community's property, the property's common areas. Or a mentally ill member's actions could cause them to fail to maintain or cause damage to their own lot or unit, and that could affect property values in the community because, people driving through are seeing these properties and maybe they want to buy the house next door, but then they look at the neighboring house and they're thinking to themselves, well, I don't want to live next door to this, right? So this is just something, that we need to keep in mind too. The point of a community association is to do these 4 things. And so we have to do things within our power to make sure that those 4 things are protected. And that includes, equipping managers and board members with the tools that they might need to handle mental health issues when they come up. Now, case in point 2, a client came to us, kind of while we were in the middle of coming up with this presentation. And she mentioned that every night a homeowner was reporting to her that her neighbor would spend hours digging deep holes in his front yard. So of course, this neighbor was later found out that the neighbor had a mental health issue. And in addition to keeping everyone up at night, the homeowner was afraid that the resident might be dangerous. And then she was also concerned that she would be unable to sell her house due to the state of the neighboring yard. So the association's prior attempts and enforcement had failed. They probably followed their enforcement policies, sending this homeowner letters, so on and so forth. And the owner's family had pretty much washed their hands of the resident. So social services had to kind of become involved, and then the resident was placed in an assisted living facility. But, what are the association's obligations when it comes to advancing these purposes and obligations that I'm talking about? A key obligation of the association is enforcement of their governing documents. And of course, we're not saying that a board or a manager is responsible for carrying out certain things when it comes to a resident. But whatever duties that the community does have, it needs to make sure that it goes about the business of enforcing them, so that in the situation where the community gets sued, you have a good defense, because you can say to a court or you can say to a jury, listen, we followed our procedures to the best of our ability, and we are not mental health professionals. We are not necessarily equipped with the tools that we need to handle this kind of situation, but we did achieve our purposes and we met our obligations. And so we're good on that aspect. All right, so now I want to get into the best practices. And I think this is the most important part of the entire presentation, because it gives you what you need in order to be able to handle certain situations. Now, I mentioned at the beginning of this is that it's not necessarily just tailored to community associations, because you can use these best practices in your everyday life. You can use them in other organizations that you're involved in. I think that this just kind of helps, of course, some of them will be, I'm going to say, the community association needs to do this. But if we just kind of, think about, these best practices and couple it with the other information that we've talked about today, I think that we can all benefit from it. So the first thing that we do is we try to educate management and the boards. And part of that is presentations like this one. Boards and management need to understand that their role is not to provide mental health or assisted living services to their residents. Rather, they are intended to make sure that the community is operating to the best of its ability to meet the needs of the membership on a uniform and equal basis. And they also need to make sure that they're enforcing the community association's restrictions towards the goal of preserving those property values and protecting them as well. So of course, we might instinctually want to help a person that we see suffering from a mental health episode or some sort of mental health illness. And of course, that's fine. We want to make sure that we help people when we see that they're in need. But also when we're in positions like the management and the boards, we need to make sure that we are understanding the legal boundaries that are put in place that actually prevent the association from being liable for some sort of action that someone has taken. And not only are we looking at liability, but we're also looking at the fact that some sort of duty might be created by an action that we've taken. So we want to just make sure that we are doing what we need to do. And if we see that there is some other situation occurring that needs assistance somehow, then we take the steps to find that assistance, but that we may not be having to do that ourselves, right? We want to document everything. This is especially important in the community association context, because oftentimes these things, they end up in court. And so, in order for us to be able to prove up our case, we have to have documentation and evidence of that. So if there are incidents that happen, we need to keep detailed records of those. We need to make sure that we keep statements, homeowner complaints. If there are witnesses, we try to get statements from them. We do want to make sure that we keep our board members informed of any developments, and then consider involving legal counsel at an early stage so everyone is aware of the issue and can provide guidance. Because if at a legal stage, if legal counsel can prevent things from getting to a lawsuit, then we will certainly do that. Sometimes they can be resolved more amicably, and so we want to take the steps to do that too. Now, under the property code, the homeowners have a right to request a hearing before the board. So sometimes we need to take that step and schedule a violation hearing, because not only does that give us the opportunity, just, the space and opportunity to have everyone heard, but then we can make some observations during that hearing as well. So if we're seeing that there might be some mental health issues involved with a person during that hearing, then that can kind of signal us that we need to take some additional steps. But also keep in mind, what I mentioned at the beginning is that we don't always know what a person is dealing with or whether or not their disability or impairment is something that can be seen. So we just need to just kind of look out for any sort of indicator so we know what exactly we're dealing with. Now, if all else fails, if the enforcement actions that the association has taken do not obtain the compliance that we're looking for, then the association might be forced to obtain a court order to stop the resident's behavior. Maybe we need a restraining order or an injunction. We're not sure, but that's another time when we need to just like make a good evaluation of what's going on. And then make sure the association really understands the pros and cons involved so that we can get the board to make a good decision about whether or not we need to actually proceed with legal action. We can also engage government assistance. The government has a lot of it has a national database of a lot of resources, state social services resources, things that or agencies that can be contacted to provide assistance to mentally ill community members, whether or not that person is an adult or a child. And those agencies will have the knowledge and the skill base to take action and provide care for a mentally ill resident if that becomes necessary. Also, you know, I've had situations where we've had to reach out to family, which kind of is in conjunction with number 5, because they could potentially help as well. So consider government assistance where help is available. But then also, if the association has gathered emergency contact or family information, then it is a good idea to reach out to that emergency contact or family member to try to get a good gauge on what's going on, or maybe to alert the family or emergency contact of what's going on, because maybe they don't know. You know, a lot of times family is unaware of the extent of a person's mental illness, and sometimes they will step in to assist, not always. There are situations where you can't locate family or the family declines to get involved. In those cases, then the association should default to the government assistance that I just mentioned, rather than taking on that job yourself and trying to provide some sort of care for a mentally unstable resident, because first, you don't have the obligation to do that, but second, it can create a lot of liability and create another duty. Another best practice is to adopt policies, procedures, or whatever, and make sure that they get followed, because these policies or, you know, governing documents, they are there for a reason, and they should be enforced when issues come up. So establishing a procedure to allow membership to log complaints or report incidents involving violations of the governing documents is a good step. Adopting an amendment to the restrictions that authorizes the eviction of a resident as a result of nuisance or dangerous behavior, that's also something that you can take into consideration. But again, you want to reach out to the association's legal counsel to make sure that is something that's available to them. Another thing is to make those resources available. You know, the ones that I was talking about as far as the government assistance or, you know, any other local resources that you might know about, perhaps putting this information on the association's website where residents can go and obtain that information. They can seek maybe their own mental health help, or, you know, try to deal with their own mental health challenges. And of course, the tagline for this doesn't have to say where to seek help if you're crazy, right? But it should be more empathetically described as resources for those who are suffering from anxiety, stress, or another mental illness. You can also host community activities that are aimed at mental health. There's a reason why wellness resorts and retreats exist. Those facilities and the classes offered there are aimed at promoting life balance, healing the person, healing yourself, and engaging in the present moment. And to that end, perhaps it's a good idea to explore offering group classes for the membership. These could be aimed at fostering mental health, like meditation, I'm lawyer mind, mediation, yoga, or even a book club or something like that. You could even like reach out to the community and see what they might be interested in. You know, of course, this is not going to solve the mental health crisis in America, but it doesn't hurt to offer options that may offer up some sort of temporary relief from the stresses of the world. Now, if all else fails, sometimes you're just going to have to call the cops. If something completely unhandleable is going on, you might have to call the cops. A lot of times we have to remind our clients that, you know, claim various crimes are afoot, and they want to take matters into their own hands, that community associations or HOAs are not law enforcement agencies. When they're confronted with a situation that might require law enforcement, then they need to call the cops, especially when it comes to fears for safety in the community, those sincere fears for safety in the community. And perhaps even if there is a mentally ill resident that is exhibiting some behavior, then the association should seek out that legal enforcement, that law enforcement help, rather than try to diffuse a potentially dangerous situation on their own, because they don't want to jump into a lion's den of activity. And then finally, call the lawyer if there are some issues happening. Of course, I mentioned a couple of different stories where our clients have reached out to us to, help them come up with a way to deal with some sort of mentally unstable resident, or they weren't even sure that there was some mental health issue happening there. And we were able to kind of dig a little bit deeper and, figure out what exactly was going on with the situation, kind of get to the root of the issue. And so sometimes you need to call the lawyer just to kind of figure it out. All right, so the last slide that I have is just some of our final takeaways. We talked a lot about the stats and mental health, and our country is definitely divided. Mental health is at a low point. Civility is at an all-time low. And this is not just with community associations, but this is in general. And so boards and management, I should just say, people in general, we should lead with compassion and empathy. And that should be a full sentence right there, leading with compassion and empathy. But specifically when it comes to this topic, while complying with our enforcement provisions, the things that the board and management are supposed to do, they should do those with compassion and empathy. You also want to make sure to avoid emotional involvement in a resident's mental health struggles if possible. I know that can be very, very difficult to do, but taking the emotion out of situations really helps to kind of get them resolved a little bit easier. And then doing what you're doing right now, getting as educated as you possibly can on, mental health issues, legal issues, and then providing our client with best practices is essential. So I don't know how much time we have for questions, but I will go ahead and stop right there. Thank you guys so much for your time today.
All right. Thank you, Ms. Hicks. That was good information. I did not know that there were so many differences that property owner association had in comparison to into the laws we have on the books, federal and state. I did have one question that was asked in the chat room. Said that, are there government agencies that provide funding to property owners accommodate for accommodations that are too expensive?
I'm not sure about the answer to that question, but I don't know. I don't see why that wouldn't be a thing. But, community associations are supposed to have funds on hand for any improvement, whether or not that improvement comes at the request of a reasonable accommodation or reasonable modification, actually. So if they don't have reserves, then they might have to, go into looking for loans and things like that. But that also comes into play where that sort of accommodation might be a financial burden. And so they might have to deny the request if that comes up.
Right. Right. I know for some, at least I've seen or heard with some of the builders or home remodelers that there's funds sometimes, but you have to put a request in and let it be known that you may need funding or help for that type of thing.
Yep, absolutely. Absolutely.
Yes. Okay. And for everyone that needs, if you require a CLE certificate, I have put the passcode in the chat box. Please check the chat room for the passcode and send me an email along with the request for the certificate. I'm going to post it again. But yes, does anyone have any questions? Please feel free to unmute and ask Ms. Hicks.
I'm going to stop sharing so we can just see everyone.
Okay.
No, it doesn't look like any more questions are coming in.
Yeah, no more questions. But again, feel free to unmute if you do have a question. Yeah, this was really interesting. Yeah, everyone said, I'm looking at the comments. Great presentation. It's good information.
Thank you guys so much.
All right, going once, going twice.